Our next dialogue is going to be by Mr. Jyoti Sagar, founder J. Sagar Associates and KNS Partners. Now, Mr. Sagar has been practicing law since 1976. He is an associate president of Society of Indian Law Firms, member of the Executive Committee of the Bar Association of India, and also one of international vice presidents of Asian Patent Attorneys Association. He's also worked on several policy issues and has been associated with various committees of the Government of India and Chambers of Commerce. He's pioneered a new paradigm in Indian law firm organization and management structures. Both JSA and KNS have features which are unique to Indian law firms: a no family rule, admittance to partnership without goodwill buy-in, retirement age for partners, innovative partner compensation mechanisms, and shared vision, mission, and core values. Today, Mr. Sagar will be talking to us about new horizons for legal services, banishing legalese, and adopting plain legal language. With that, I would like to welcome Mr. Jyoti Sagar on the screen. Delighted to have you, sir.
Thank you so much. So I actually chose to speak on something very different. And let me start with a story. A few years ago, a genteel lady who was not a lawyer, walked in to my office, and she had some legal issues that she was trying to deal with. And she asked me a question. She says, what is it that when I read a document, a party of the first part is doing something or the other to the party of the second part, and then there is so much of Latin, there are so many words. Why do you lawyers need to write like this? And I still do very distinctly remember that she actually, from her own document, she pulled out this. She said, now therefore, in consideration of the premises, the representations, warranties, covenants, undertakings of the parties hereinafter set forth, and for other good and valuable consideration, the parties agree amongst themselves as follows. So she says, well, why can't you just simply write, the parties agree as follows? Actually, that was an interesting inflection point for me, because ever since I started the study of law, and then interning with a law firm, I always was, a little bit amused, with our language, the language of the law, the legalese, as it's called. But I didn't really pay much attention to it. One went through the entire practice of law, writing contracts, writing opinions, reading judgments, but not paying much attention to this. Until this particular instant actually really aroused my curiosity. And I said, well, let me just start thinking about this and looking at this a little bit as to what is it that is so peculiar and so distinctive about our language of the law. And it became a kind of a, study material, so to say, for me. And then I realized that it's not now that people make fun of what the language of the lawyers is. The earliest references that I personally found was Jonathan Swift in Gulliver's Travels, and he talks about a society of lawyers who speak in a peculiar cant and jargon of their own that no other mortal can understand. And then I looked at a couple of sort of important, critical issues. That in a way, we lawyers are in the communications business. We communicate thoughts and ideas. We produce documents. The tools that we use are the words. So we are word-smithing all the time. And if our role is to communicate, then our readers and our listeners must understand us. Otherwise, we are failing to communicate. And that's at the core of it. And you keep on realizing more and more now that the audience for lawyers is just not judges and other lawyers. Today, law touches everything that we do in our lives. People need to know their rights and responsibilities as much as a manager needs to know what is in a contract that he's supposed to be implementing. And if he can't understand that, or if she can't understand what her rights and obligations are, then quite frankly, what's the point of writing materials and things which people cannot understand easily? So I kind of became a little bit of a passionate student of this subject over the last few years, because one of the tragedies, of course, is that, and I'll talk about that a little later, that in our law schools or even in the profession itself, hardly any emphasis is given on language skills, and particularly on plain language skills. We all learn from whatever is there and has existed in the past, and then we just simply continue to write and speak like that because we just simply believe that that's how lawyers write and that's how lawyers speak. This is a special thing. Now, as I kind of looked at this further and read more about it, so two things that emerge as to why is our language, the legalese, so peculiar. Really, two reasons for it. One is the words themselves that we use, and the other is how we construct with those words. So to give you an example, so we will use words of antiquity like heretofore, whereas, therefore, and so on. We would use a lot of Latin and French words. Then we use pompous words. And then, of course, jargon. There's a lot of jargon. And then eventually we also use too many words. Verbosity is a big problem. On the construction side, you got words, now you got to put them together. So what do? We have long sentences. We use passive voice, very pompous language. We use compound constructions and several other techniques that we use, which frankly make the English that we write and we speak very, very different from what the common person would understand in English. And I'll just give you one example. It's interesting. Now, the word executed, for example, for us lawyers, it means it's a signed document, or signing a document is executing a document. And what does the rest of the public think it is? Well, either putting a plan into action or carrying out a death sentence. And there are a number of such words that we use in our language which means something totally different in other languages, or rather in the commonplace English that we use. Then we use a lot of Latin. And again, a client of mine actually asked me once, do you speak Latin in the office or Latin at home? Or did you study Latin? So I did confess to him. I said, you know what? We are supposed to mug up all of this stuff, and then we have to pour it down on a piece of paper. So he said, but why can't you use normal, simple English equivalents for those? Why do you have to use Latin? And then I thought to this and I said, okay, one of the big reasons why we also try and do that is, and in fact, that light was thrown to me by a young attorney who joined my firm. And I mentioned to him that personally, I do not like too much use of Latin. And he said, but sir, Latin makes you, when you write these Latin words, they make you look very scholarly and very learned. Now, that's the impression that we as lawyer community carry about Latin. Not one of us, certainly in this country, in India, has actually formally studied Latin or not, but we use it because that's how it is. Now, then we will use fancy words, like I will ascertain rather than saying find out. We will endeavor to do that rather than saying we will try to do that. And we always advise. We do not tell or inform, and we are always advising. We will say consequently rather than saying thus. And of course, the jargon is quite amazing. And we as lawyers, we think that a lot of our language, and that's one of the problems we have, that a lot of our language is precise. So therefore, all the words that we use are precise. And this is kind of, let's see. It is true that almost all professions, they have their, some writer disclaimed their vocabulary, which is sort of fuzzy, wuzzy words of that profession. So whether it is a plumber or a doctor or a lawyer, they all have these fuzzy wuzzy words, but we are in the unique position that our fuzzy wuzzy words actually have a definition, and that is legalese. I don't think so any other professional language even has a name. So one of the things that we are very proud of is that these are very important words which carry a specific legal meaning, or as we would describe and we'll say term of art, which means that by persistent professional use in only one way, a certain word achieves a specific legal end or a legal meaning. Some examples that most people will also understand. For example, mortgage, lease, a lessor, or the concept of an injunction, even plaintiff, defendant. These are all actually term of the art, and most people understand that. But there are many other words actually. In fact, a lot of what we claim to be term of the art or special language is actually simply jargon. Most of those words have no legal meaning whatsoever, but we tend to use it. For example, quote below, four corners of this instrument, purported. This case will be set down for hearing, hereof, thereof, whereof, and all of these fancy words that we use, and actually they carry literally zero legal meaning many a time. There is also the problem that we use of big words and too many words. Like I found this very interesting, and I like to kind of read this. So there was an advice which said, and quite interestingly, tongue in the cheek, don't use a big word when a singularly unloquacious and diminutive linguistic expression will satisfactorily accomplish the contemporary necessity. Now, I know Dr. Shashi Tharoor is known for his vocabulary and his big words, but the point here is that for us as lawyers, we are communicating, whether I write, with someone writing a judgment, which is going to be read by some lawyer in a Mufassil court in way out, Bihar or Jharkhand or Rajasthan or any of the interiors of the country, who's trying to understand the law. And if the judgment is written in words that you cannot understand, that you need a dictionary to understand those words, then you are actually failing in your task, and we don't realize that. And same for us as lawyers writing opinions or writing contracts. If people don't understand because the words are so long and they are so difficultly strung together. So let's see. Construction styles, long sentences. We can have one whole page which is full of one unbroken sentence, and it becomes absolutely impossible for even lawyers to understand that sentence, because what we do is we overburden the sentence. We put the main theme in the same sentence, all the details, the qualifications, the consequences, the conclusions, we put them all in one sentence. And there is a simple way of dealing with that. For example, that if you say one sentence should have just one thought, and if you maintain a sentence length which is on average about 20 words per sentence, which is by research now shown as is the ideal length in a way to keep a person fully involved in the document and to fully understand the document. I mean, this is now psychology of reading, and there is research which is now going back 100 years which suggests that. Then we use the passive voice. We don't use the active voice. And active voice is the usual way that human beings' brain works. That the subject in a sentence is doing something, that's verb in the sentence, to someone else who is the object of that action. But most of our time, we tend to use the other way around. So we will not say the union filed a complaint, as an example. We will say a complaint was filed by the union. So it takes away the action in the sentence. It takes away the action from the verb in a way. But what it does is it creates difficulties in for people to understand, because the human mind, in terms of the way we understand language, is wired very, very differently. Then let's take some other examples, some of my favorites. You can call them compound constructions. See these words: in the event the plaintiff files documents. Now, in the event, we can just simply replace it with if. I mean, if I go home and I say, in the event I take the train, I never speak like that, right? I will say if I take the train. But when we lawyers sit down to write or sit down to speak in a legal context, we simply create these very interesting, long compound phrases which can be replaced just by one word. We'll never be right is desirous of. The single English word simple is wants. Or we write in the course of doing this instead of saying during. Most of us will use the word in order to instead of just to. So the lawyers would rather say in close proximity and not say near. So these are some of the examples of how we lawyers use our language. We have created this language over centuries. Some of the things that we do have a history of 1,000 years, and the history of the long sentence is probably even longer than that, for example. And all we've ended up doing is making people, as I call it, law sick. And when you look at the history, it's amazing that how over the years, fantastic lawyers, great writers have actually commented upon this and criticized it. But we, as the legal profession, we have not learned, we haven't understood that our audience has changed now. That commonplace people on the street who needs to know their rights and obligations, who need to understand what their constitutional rights are, who need to understand what their, what the tax law is and what kind of taxes apply to them. Or a simple thing like, I get a warranty for my air conditioner or for my car, or I have a life insurance policy. And just try and read that document. Try and figure out what it is saying. And you can't. You probably have to hire a lawyer to tell you that what the insurance policy covers and what it does not cover. So I have sort of started to wonder more now and in recent times to say, does it really have to be like that? And why do we persist in this? And clearly, I think one thing is, frankly, I find it's almost like lethargy, that we don't care about the most important thing, which actually is the core part of our interaction with rest of the society, and that's that their understanding of what we are saying. So why do we persist? There are people are saying there are sociological rationale, like Jeremy Bentham. He complained of this is 100 years ago. He says lawyers deliberately use a complex language. And another person wrote, if lawyers' language serves as a secret handshake in a fraternity, letting others know that you are one of the tribe. So, as I was mentioning, basically, we are not taught how to use the language. We are not taught how to communicate. There are hardly any proper language and writing skill courses in the law school. And when we join the profession, we are just handed down something which has been handed down from generation to generation. And you are supposed to write and talk like that, with the fear that if you don't, then you are almost unprofessional. You are unskilled. So many countries do have today a plain English movement, whether it is England and US and Canada, Australia, New Zealand, all the countries which have a common law background. Most of them have plain English movements, whether it is legislation or whether it is consumer documents, because people are realizing what law is. And in fact, writers have gone ahead to suggest almost that with this difficult language, it actually is almost like an access to justice issue for most people, because they don't know what the law is and they cannot access law the way they should. So a lot of countries have very strong plain English movements. And in fact, in the US, I think it was 2010, we had in the time of Obama, they actually have a plain writing act passed by the Senate in 2010, that all the government documentation and forms and so on have to be simplified and in plain language. And in many of these countries, the legal profession has led this. And I do hope that in India, we have taken some small baby steps at the Society of Indian Law Firms and elsewhere to start this campaign. And the users of the legal services, particularly, and I'm addressing the general counsel community, that they can play a very strong role in this. They can insist that their external lawyers write to them in simple, plain English. Sorry, it's a long monologue, but I had to give you the background to it. Otherwise, the rest of it would not have made sense. So, Anurag, over to you.
Thank you, Mr. Sagar. It was fantastic, and again, you made it philosophical and specific both at the same time. And I was waiting when you talk about Shashi Tharoor, and it came in when you were saying all that. Now, I want to talk to you about many things, and two of my editorial colleagues, Shirupa, ex-colleague, who started BW Legal World for us, and Ashima will ask you one question each. But what you explained to us, what led to this unnecessary and incomprehensive language in legal affairs. And you talked, your colleague said to you, it makes you sound intelligent. You don't use the word. So, how do you think it can change? What in today's, your speech can create that consciousness to simplify your... But what do you think can change this?
So first of all, just 1 second or a few seconds on the historical background, because we inherited this from the English. Along with English law came English, and along with that came the language of the law, the way it was used in England over a period of time. And there are a lot of history. There actually is a long history of the language of the law, and also how Latin came in and how these complicated words came in, which are actually from Old English, which kind of finished in the year 1000 AD. And a lot of words from Middle English, from say Norman Conquest 1100 to about 1500 AD. And then the modern period, but the rest of the world gave up those old words, and nobody writes today like Shakespeare does. But just I put in context, but we do. Just imagine if everyone today wrote like Shakespeare does. You understand what I'm saying?
Right.
The second piece really is that you need to have, a certain core mass, within the legal profession, which will adopt this. I give you my own experience. I would not take the name of the firm. This was about 6 years back, where a colleague brought in a document which had 1 page, 1 sentence, and I told him to make it into shorter sentences, to give titles and subtitles, and send it back. The whole thing came back fully restored with a snide comment: lawyers don't write like this. And that's the point in time that I realized that unless there is a critical mass, this thing can never change. And this change was led in the early 90s in the UK by London, the big London law firms. So I did write to the peer firm chairpersons, so 2 years back, and we've been slowly working on it. And I want to hasten that space to say, folks, unless the leaders in the law firm community start adopting this, and if we do it, then everybody else will. And several of them are on this panel, your fantastic day full of all these interesting events, who said, absolutely, we need to do this. So at the Society of Indian Law Firm level, we did have our first kickoff introductory module in July. And then we are planning to do some training modules, some tips and techniques of how to simplify the language, at least as a beginner. But I think it needs to go to the commercial world. It needs to go to the corporate world. People, for example, I was telling about insurance policies. If you just take out the warranty card for your refrigerator, you can't make head or tail out of it. You need a lawyer to tell you what is covered in the warranty and what is not.
Conditions apply. So
correct. The proverbial small print, and which is full of legalese, full of rubbish words which completely confuse you and don't let you understand the meaning of what it is.
Absolutely right, Mr. Sagar. And dare I say, in journalism also, brevity is the soul of wit. They say, if you write a good journalistic piece, it has to be very, comprehensive but tight. And I have heard law firms saying, "Oh, you saw my draft? I have responded in 36 pages." So it's become a bragging rights if the paperwork is long and it's verbose, right?
That's right.
You have to go in a different direction. At this point, I want to ask you this question: is our legal education curriculum keeping pace with the ever-changing legal and business environment? What should young lawyers do? Tonight, we'll unveil the list of these top 40 young lawyers and legal influencers. What's your advice to them?
Yeah, well, this is an interesting area, again, where I've been sort of trying to spend some thinking time. But clearly what we are seeing is that nothing much has changed significantly in the last 60 years in the way legal education is dispensed. Apart from then the introduction of case law method at that time, nothing significant has happened. And of course, there are national law schools and some other excellent, private law schools which are doing a much better job. But on a very large scale, we produce over 100,000 lawyers a year, and the quality is very poor. And even through the best institutions, the people who come out, they do not come out in a way that they are ready to take on the practice. And these are simple skills like relationships, like practice management skills, time management skills. How do you sit in a meeting? Your presentation skills. The entire area of emotional intelligence, as an example, which is in this day and age so critical, because it's not like that most lawyers are just going there. Many go into the system, into the normal legal litigation system, but many young people are coming into law firms, going in-house into companies where they have to work. They have to understand how to work with juniors, peers, seniors, how to handle things. And, they have zero clue. And I've had these experiences where a young associate has been given a piece of work by a senior associate. And then the partner calls this young associate and say, do this immediately. Now, this person has zero idea how to deal with that situation. But the problem is that in legal education, we deal with cases which are on paper. And in real life, we deal with people, whether it's a difficult client. Is a difficult client on the phone. How do you deal with that situation? You're in front of a very difficult judge. How do you deal with that situation? So in terms of actually practice, I do know that many of these things can only be learned when you're actually practicing. But there's a lot more that can be done in the law schools by proper changes in the curriculum to make it more practice-oriented, to make it more practical, and not just merely theoretical. And even in terms of technical subjects, things like FEMA or securities laws or M&A, a lot of that is not really even taught, which are the things that are current in today's world. So I think there has to be a thing while there should be a basic 3-year program which everyone follows. And the last 2 years should actually be very much focused with new contemporary subjects, new ways of doing things, legal clinics, setting up a legal clinic within the college with help with senior teachers where local people can come and seek advice and legal guidance. So those kind of things that you need to do. And, what are those skills? What are those competencies that you really need when you have to practice law? and how much of that can we impart in the law school?
Thank you, Mr. Sagar. I could go on doing a 2-hour conversation.
I mean, the last, there is,
yes,
we know it's really changed in the curriculum. Sorry, Anurag, I couldn't hear you.
I said I could go on doing a 2-hour conversation, and we'll hopefully request you for that on video sometime soon. But at this point, I want to bring in my colleague, Ms. Ashima Hori, who's the editorial lead at BW Legal World. She's co-curated this conference. That's a fabulous job for us. Ashima, go ahead, ask your question to Mr. Sagar.
Hello, Mr. Sagar. It's a pleasure to be speaking with you today. And I've heard your discourse on this, and I was quite interested in knowing your views on how will this impact legal tech if we do away with boilerplate clauses or universal understanding of some of these languages of the clauses. Will this impact us in any way?
No, I mean, it doesn't. It makes things easy. So no one is saying replace mortgage by a long description of mortgage is. There are terms of the art and they have to stay. But there is a lot more, as I gave examples after examples. I mean, in the event that, legal tech will not be worried. In fact, they'll be damn thrilled if it is if. And today in Microsoft Word today, there is that feature when you're reviewing your document, it actually asks you for clarity and for conciseness. They're doing it today. So, yes. I mean, the tech is very happy with it. Techies don't like long words and techies don't like verbose stuff. They are very precise.
That's great.
We have this idea of precision of legal words, and I keep on telling people, if our words were so precise, then how come there are 70 volumes of judgments on words and phrases legally defined? There are 1,300 judgments on what the word shall means. Think of it.
That's true, sir. The interpretations are just mind-boggling.
So it's not that our language is very precise. Otherwise, you don't need 70 volumes of words and phrases legally defined.
I think as a student, I would have been pretty thrilled about not having to mug up all the things that we did, the Latin phrases and the questions we were asked.
That's right.
Thank you, Ashima. I also want to bring in my ex-colleague, but she's still very much part of the BW business world. She started BW Legal World for us, Sri Rupa Chaudhary. Sri Rupa, go ahead, ask your question to Mr. Sagar. Sri Rupa.
Thank you, sir. Thank you, Dr. Batra. Mr. Sagar, great topic. Very few stalwarts actually speak about the need to reform the legal industry. So taking from Ashima's question, I'm very curious to know if you think that lawyers are kind of insecure that if legalese goes away, then artificial intelligence will kind of take over drafting of legal documents and things like that. And their very existence kind of depends on laymen not understanding legalese.
Yeah, I think, this was always a profession of the elites. And when you go into the history, why French words and Latin words were used, French and Latin were actually the official languages of the English courts right up to the 17th century. There were 2 laws passed in England, which said English is the language of our courts to that extent. So the elites maintained the profession. They actually had a monopoly over the profession, but things have changed. Now law concerns everyone. It just doesn't concern lawyers and their feathered nests. It concerns you, it concerns everybody on the street. And we have to, as service providers, deal with the audience, not with our own needs. We have to deal with the needs of the audience. That's why change must come.
Thank you, Mr. Sagar.
Right, sir. Right. And we have to make it simple for everybody to be able to engage with the law, basically.
Exactly. And when people are using pompous big words, they're doing it to show off. They don't have to. If your reader has to run to a dictionary to find out what you're saying, you failed. Basically, you failed.
Mr. Sagar, you're so right. Now, I want to ask you a question that I've been wanting to ask you for a while. If I'm not wrong, you've been practicing since 1976, right?
Yeah, and before that, 4 years in a law firm as an intern.
So you've been now working for 48 years.
48 years this June.
Yes. So you are one of the only ones who has pioneered a new paradigm in Indian law firm organizations and management structures. Both GSA and KNS have features which are unique to Indian law firms: no family rule, admittance to partnership without goodwill, buy-in, retirement age for partners, innovative partner compensation mechanism, and shared mission and core values. Tell us now, in your role as a mentor, as a leader of the family, how has it worked for you, and what do you have to say to other law firm owners and the legal community that you in some way lead?
First of all, I think one clarification that what's happened, we may have been the first ones in some ways, but there are several other younger firms now who are coming along. They are exactly looking at things in a more structured and I would say, more say Western-oriented manner versus having either a family-controlled firm or a firm which is, controlled by a couple of, legendary individuals. A lot of the firms are going the model of a collegial, professional partnership. So it's, and I would say that in our country, I think it's work in progress. These are still early nascent days of these sorts of models. And we still think that what we are doing in both our firms are clearly, early days. It's a very bold experiment, and we are seeing how this works. And some of the top firms in this country, very powerful firms, are family controlled or run by very, very, amazing, legendary people, and they're doing very well too. So in a way, I think it's different strokes for different folks. And you're trying to see, can you do a paradigm whereby you can actually see that institutions can be built, which survive and outlive the founders and create a place for themselves, as has been seen in the more developed Western markets, particularly, or even now in the Eastern markets. So it was an experiment, and the experiment is still on.
Mr. Sagar, you achieved everything. You built a successful law firm. You have respect, even more respect.
I couldn't hear you. I couldn't hear what you were saying.
You achieved everything that you wanted to. You have so much respect in the profession. You built a top-tier law firm which carries on work with your supervision and mentorship and not full involvement. Is there anything left for Mr. Jyoti Sagar to achieve? Does Mr. Jyoti Sagar have a bucket list? Mr. Sagar? Were you able to hear me?
Yes, sorry, we lost each other for a little while.
I said, Mr. Sagar, you achieved everything. You have a top-tier law firm. You have tremendous respect. People behind your back give me examples of, see, this is a man who's really, kind of passed it on to the next generation. You achieved everything. So is there something for you to be achieving more? Is there a bucket list Mr. Jyoti Sagar has?
Yeah, well, first of all, thank you very much. I mean, we do try and do our best, and I'm happy and satisfied with what, wherever I have gotten. Good things, bad things, they all come as a package, so that's fine. Do want to work on certainly 2 or 3 of these things. First, of course, is this plain English thing is quite close to my heart. The other one is this curriculum. I mean, I hope to start doing something more significantly. And then there are some groups who are working on issues of pendency in the judicial system, pendency in the court system. So I'm trying to do a bit with some of those folks as well. So these are the 2 or 3 things which keep me occupied. And then, of course, we have 2 foundations that we do. I think you are familiar with one of them, at least, the Genesis Foundation, which supports poor children with congenital heart defects. So I am the trustee there as well. So that takes up my time. Plus, there is a foundation we have which runs a center for differently abled slum children. So about 15-20% of my time goes into that. So there are things to be done. There's always something to be done, and you got to keep yourself busy and mentally agile and involved and enjoy life and all its various facets as it presents itself.
My last question to you, Mr. Sagar. Throughout this 48-year-old journey, I'm sure you've touched the lives of many people, professionals, individuals, companies. But tell us people you have been inspired by. Give us 2-3 people who you have been inspired by personally and from whom you've learned and why.
Well, that's interesting. I mean, I've run into several excellent people, both in the profession and outside of the profession, and I have learned a lot. And learning is a continuous thing. You never learned enough. It's always enough space to learn. But the 3 people that I have always acknowledged and as my mentors, one is my uncle, with whom I worked for 19 years, Dr. Jyoti Sagar. I learned a huge lot from him. In particular, again, the question of entire articulation and writing skills and so on was how to look at a problem, and also handling clients with different cultures. So that was something that I learned at his feet. Then there was another senior of mine in my uncle's old firm where I worked for, as I said, 19 years. So for almost 10 years, I worked with another legendary senior of mine. His name was Mr. Amar Raj Lal. And from him, I learned the entire thing of how important it is, how important the detail is. And he used to always say, assume nothing and show me. So if I were to tell him something, that this judgment, this happened, he would want to see that paragraph from that judgment himself. So he used to say, assume nothing and show me. So those are and I worked with him on many complicated matters as a young lawyer, and he was legendary. He was an outstanding professional and an outstanding teacher to me. And then third was another gentleman called Mr. J.K. Call, who was a bachelor, old lawyer in the firm, and I was his understudy for a few years, and I really developed a friendship with him. And he was an incredible guy again for detail. And he would always say, I still remember, I'd sit in front of him and he would say, padho, read. And then he would not say gadhe, but he would say Gadhe. I still remember. And, so he just instilled in me that, look, you have to get down into the detail and you have to understand things and you must read. And even now, it's an irritating habit that I have for many people. Some paper will come in, something comes in, and my instinct actually is I open the envelope and I open it and I start reading it. And my wife Prema will say, "What the hell is this? What are you doing?" I said, "It's just in me. When I have something in front of me, I'm going to read and try and understand what it is." So that was Mr. Call's legacy, and so those are 3 people I've kind of always acknowledged. I mean, they really in a way framed me in a way. They changed me and they made me what I am.
Thank you, Mr. Sagar. It's been a pleasure and an honor to have a conversation with you. I'm sure our audience have enjoyed. And those of you who want to revisit this conversation, Monday you can visit the bwlegalworld.com page. All the videos will be live there. So if you want to revisit and learn from what Mr. Sagar said, please do that. The October edition of BW Legal World will also have Mr. Sagar's full interview transcript and his address transcript. I look forward to doing a longer conversation with Mr. Sagar. I hope I'm able to do that soon. I requested that about 2.5 months back, and you agreed last week. So I hope we can find time to do that and dive into more aspects. Just to give you the gist of what Mr. Sagar said, one is make things simpler. Simple is more effective. Second, he quoted his mentor, assume nothing. And third, he talked about the fact that reading helps. Fourth, life skills help. Interdisciplinary knowledge helps. Grooming helps. How to address someone, how to conduct yourself in a meeting, what not to say. So those life skills are very important. Time management. So while legal, technical knowledge is important, going forward, if you want to be, as a young leader, be successful, follow what Mr. Sagar said. Thank you, Mr. Jyoti Sagar, for talking to bwlegalworld.com. and we look forward to more interactions and conversation with you. Thank you for inspiring all of us and being the pioneer that you are. Thank you so much.
Thank you, Anurag, for giving me this opportunity. I appreciate it. Thank you so much.
You're very kind, sir. Thank you. The pleasure is all ours. Thank you.